Hello, I'm Ajobaku, an analyst with the Office of the Saskatchewan Information and Privacy Commissioner, or the IPC.
Hello, I'm Andrew Livingstone, an intake officer with the IPC.
Welcome to the IPC's webinar on the role of intake officers and analysts. The IPC is an independent office of the Saskatchewan Legislative Assembly that oversees 3 Saskatchewan statutes which establish the access to information and privacy rights of citizens: the Freedom of Information and Protection of Privacy Act (FOIP), which applies to provincial government institutions such as ministries and crown corporations; the Local Authority Freedom of Information and Protection of Privacy Act (LAFOIP), which applies to local authorities such as cities, school boards, and libraries; and the Health Information Protection Act (HIPAA), which applies to trustees of health information such as doctors and health clinics.
Outside of a formal review or investigation, we can only provide non-binding summary advice.
So Andrew, as an intake officer in the IPC, what's your role?
If you email or phone our general intake line, you would speak with an intake officer like me. As we just mentioned in that subtle disclaimer, I can provide a certain degree of non-binding summary advice outside of a formal review or investigation. That's convenient because a lot of people who contact our office require only basic information. They may not even know what our office does, in which case I can explain that. It's very common for somebody to have a privacy concern and bring it to us with the assumption that the Information and Privacy Commissioner should be able to do something about it. In that case, I might have to explain our jurisdiction, that the Commissioner's position was created to oversee provincial legislation that applies to provincial institutions. Therefore, it's only those public bodies, like government institutions and local authorities, and trustees within the province who are supposed to be captured by the legislation. Furthermore, the legislation only addresses public bodies and medical trustees, not private sector enterprises or individuals. So if a person believes that their privacy has been violated by another person or by a corporation, then that's probably a matter for a different office. Without a basic understanding of the access to information process, a lot of people also assume that we can just locate any government document and provide that to them directly. So I might have to explain that we don't have possession or control over any of the documents that people are interested in requesting. Those are being collected, used, and eventually destroyed by the relevant government bodies and medical trustees. So those are the entities that will have to be asked to release them.
Do you tell people how they can request documents?
Yes, I often describe the process that they're supposed to follow. I might explain that they should submit their request to the public body and be as specific as possible. I might explain that depending on the size of the request and the necessary manpower, there may be fees. And if the request is to a local authority, then the request usually isn't considered to be complete without a $20 application fee. Quite often I direct them to the Access and Privacy Department within a public body. I might remind them to save all of their correspondence in case they want us to review it afterward. I might also explain that a privacy complaint is similar in that it has to be sent to the relevant public body or trustee, and our role is to review their response in the event that the complainant is unsatisfied.
But you can't do anything if the institution or trustee is outside of the IPC's jurisdiction?
No, I can't give much advice regarding a process that we don't oversee with an entity that's outside of our jurisdiction. Fortunately, I can still try to point the person in the right direction. For example, if I think that the government institution is under federal jurisdiction, then I can direct the person to the federal process. Or if they've already made that attempt, I can point them to the Federal Information Commissioner or the Federal Privacy Commissioner.
Do those public bodies or trustees ever contact you?
Yes, there are times when a public body or trustee proactively contacts us to let us know that there's been a privacy breach. This allows us to get a head start in assessing their response to the breach, and it gives us some warning that we may be hearing complaints from affected individuals.
Do people ever contact you after they've made an access request or privacy complaint?
Yes, sometimes people reach out to us because they believe that they've followed the right process, but they don't seem to have gotten a response within the time frame specified by the legislation. Often that's where our role as oversight body really begins. I would collect the documentation from the applicant or complainant that provides a full picture of what happened and when. Then I'd contact the public body or trustee to find out what's happening and see if I can assist in getting a response to the applicant or complainant. A lot of the individuals who contact us have already gone through the access or complaint processes with public bodies and trustees who are within our jurisdiction, and they've received a response to their request or complaint. However, they are not satisfied. For example, a person has applied for documents and that applicant isn't happy with the documents that have been released. Or a person has complained about a privacy breach, but that complainant isn't happy with the response to their complaint.
What do you tell them?
When those applicants or complainants make contact with us, it's my job to determine whether the request or complaint can be reviewed by our office. I can collect the documentation from the person that provides a full picture of what happened and when. I ask any questions that would clarify the situation and try to establish exactly why the person is unsatisfied. Then I make contact with the public body or the trustee to verify and clarify some of the details with them. In some cases, if I can resolve some misunderstanding or someone is willing to make some concession, then the file can actually be resolved at this stage. Usually the people at the public body already feel that they've done their best to apply the legislation though, so there's not much chance of an early resolution. That's why it's important for me to clarify and collect everything, to prepare a file for an analyst to analyze and for the commissioner to make his report. Once everything is ready, I notify both the applicant/complainant that a formal review or investigation is underway, and that's when my role generally ends and the role of the analyst begins. So how about you, Ajo? How would you describe your role?
My role as an analyst primarily revolves around the interpretation of legislation and the analysis of issues regarding access and privacy. This is broken into two main parts: substantive summary advice and case file work. With substantive summary advice, I typically provide non-binding general advice to people who call or email our office on how the legislation we oversee applies to a specific situation, interpret specific provisions of the legislation, or provide any other information that goes to the core of the IPC's work. The case file work I handle involves reviewing public bodies' decisions regarding access to information requests or investigating privacy breach complaints. With these, I analyze the relevant issues and present findings and recommendations for the Commissioner's consideration. I also facilitate informal resolution where possible.
You talk about substantive case file work. What are the different types of case files you typically receive?
The case files I receive are either review files involving an access to information request or investigation files investigating a privacy breach complaint. Now, these files will typically be applicant or complainant driven. However, there are some circumstances where an analyst will deal with files not necessarily brought forward by an applicant or a complainant. With the applicant-initiated review file, I would analyze an applicant's concerns with the public body's decision regarding their access to information request. An example of a non-applicant-initiated file involving a review would be what we call an application to disregard. This is where a government institution or local authority requests the Commissioner's approval to disregard an access to information request or request for correction of personal information they received. My work with a complainant-initiated investigation file would involve an analysis of a complainant's concerns with how their personal information was collected, used, or disclosed by a public body or trustee. Proactively reported privacy breach investigations and IPC-initiated investigations are the two other investigation files I will typically handle, not brought forth by a complainant.
That seems like a lot to unpack, so let's start with the review side. What does your role in an applicant-initiated review entail?
In an applicant-initiated review, I will analyze concerns with access to information requests made to the applicable public body in line with the provisions of FOIP, LA-FOIP, or HIPAA. An affected third party can also request a review. Some of the common issues we typically assess within a formal review include whether or not the public body or trustee complied with legislated timelines in responding to the applicant, properly applied exemptions in withholding a record in part or in full, or if the public body responded to an applicant by saying no records exist, we would review whether the public body or trustee applied a reasonable standard in searching for the records. As an analyst, I manage the submission of required documents. This would include handling requests for extensions regarding deadlines of submissions, records, and index of records as relate to a file. Once all of the necessary documents are received, I will conduct analysis of the issues and present findings and recommendations for the Commissioner's consideration. Finally, I monitor compliance by recording responses to the recommendations in the reports issued.
How about the application to disregard? How different is that and what would your role be?
An application to disregard allows public bodies to ask the Commissioner for approval to disregard an access to information request or request for correction of personal information made under FOIP or LA-FOIP. If the Commissioner approves, then the public body would not have to respond to an applicant's access to information request or request for correction of personal information. It is important to note that there is no such process under HIPAA. After the Deputy Commissioner reviews the application, an analyst notifies both parties of the Commissioner's decision to consider the application to disregard and invites the applicant to provide a submission. Due to the need for a quick decision from the Commissioner, applications to disregard are expedited. The analyst conducts their analysis once the applicant's response to the public body's application to disregard is received. The Commissioner then issues his decision with reasons and a statement as to whether the application to disregard has been granted or not.
Great. Moving on to investigations, would your role in these be any different from what you do with reviews?
I guess a huge difference would be more in terms of the substance of the analysis conducted than the procedure. When the IPC investigates a privacy complaint filed by an affected individual, the public body or trustee in question is required to complete a privacy breach questionnaire. If upon a review of this questionnaire, the public body or trustee agrees that a breach occurred, I will assess how the breach was contained, affected individuals notified, root causes investigated, and the steps taken to prevent a similar situation from happening again. If there is a lack of clarity on whether a breach occurred, I will determine whether there is personal information or personal health information involved and the authority the public body or trustee had for the alleged collection, use, or disclosure of this information. As with review files, I will present findings and recommendations for the Commissioner's consideration. Although some circumstances for informally resolving the matter may exist, this is not common with complainant-initiated investigations, so in most cases, the Commissioner would issue a public investigation report. As earlier indicated, however, there are instances where a privacy breach investigation would not have initiated from a complainant. One instance of this is in proactively reported breaches where a public body or trustee reports a breach of privacy on their part. In that case, I will, in my role as an analyst, monitor the incident and review the privacy breach questionnaire submitted with regards to the incident. I will proceed to present my analysis of the description, containment, notification, investigation, and steps to prevent future breaches to the Commissioner. Where the Commissioner is satisfied that appropriate steps have been taken to respond to the incident and prevent future occurrences, and the public body or trustee commits to implement the recommendations, the proactively reported investigation file may be informally resolved without issuing a formal investigation report. Where, on the other hand, the Commissioner is of the opinion that either the matter has not been handled appropriately, the matter is handled appropriately but affected a large number of individuals, is egregious, involves systematic issues, is of significant educational value, or the matter is handled appropriately, but an affected individual makes a formal complaint, a report may be issued.
You also mentioned that the IPC could initiate investigations on its own accord, didn't you?
I did. The IPC can learn of a privacy breach and begin an investigation where a third party in possession of personal information notifies the IPC, employees of a government institution or local authority inform the IPC of inappropriate practices within the organization, or the IPC acts on media reports. Under these circumstances, as an analyst, I will review materials received and, based on initial assessments, determine the direction of the investigation. Depending on the public body or trustee's response, informal resolution may be attempted. If unsuccessful, the file will be closed informally without a report. Otherwise, I will prepare and discuss a report with the Commissioner, which might then be issued.
Do you have any publicly available resources that guide your work?
Certainly, in my interactions with applicants and public bodies or trustees, I refer them to resources such as the IPC's guides to FOIP and LA-FOIP, the rules of procedure, and the privacy breach questionnaires for government institutions and local authorities or trustees, and the many other resources on the IPC's websites.
Thank you, Azu. If listeners have any further questions or concerns, then they can contact us at the following links.